Hi, this is Harihara Subramaniam, roll number 1009379115, and this is assignment 3 for Law and Ethics for Forensic Investigation. And in this assignment, we'll be answering 11 questions which have been mentioned for the assignments in detail as we proceed on with our answers. So, question 1. The actual question 1 is evidence that is illegally searched and seized admissible in court? If yes or no depends. Explain in detail why do you think why do you think this is the case? Are there any exceptions? If there are exceptions, name and discuss at least three exceptions. Name two relevant laws from each of USA and Canada that relate to evidence and its admissibility. Answer this question for USA and Canada all separately. Since for the first question I read the question completely, but let's go to the answer directly. As I have mentioned the brief over here in the presentation uh, about what I'm going to say, but let's start. When it comes to criminal trials, the admissibility of evidence is a core issue, particularly when that evidence has been obtained through methods that may infringe on individual rights. Both the United States and Canada address the issue with their legal frameworks, but they do so in distinctive ways, based on each country's constitutional protections. Let's see first USA's case. In case of USA, there is something called general rule of admissibility. In the United States, the general answer to whether illegally obtained evidence is admissible is simply no. In one word, long story short, no. This is rooted in the Fourth Amendment of the Constitution, US Constitution, which protects individuals from unreasonable searches and seizures. This protection is enforced through the exclusionary rule, an essential principle that prevents illegally obtained evidence from being used in court. The rule aims to deter unlawful conduct by law enforcement, promoting respect for citizens and constitutional rights. Key exception to the exclusionary rule. However, the US legal system recognizes certain exceptions to this rule where evidence may still be admissible despite a constitutional breach. Good faith exception. If law enforcement officers were acting under the belief that their actions were lawful, such as following a warrant later found to be invalid, the evidence may still be admissible. This was established in United States versus Leon in 1984, emphasizing that officers acting in good faith should not have evidence excluded due to procedural errors. Inevitable discovery doctrine. Under this doctrine, if the evidence would have inevitably been discovered by lawful means, it can be admitted in court. This was set forth in Nix vs. Williams in 1984, acknowledging that the deterrent purpose of the exclusionary rule is not served when evidence is bound to be found by lawful investigation. Independent source doctrine. If evidence initially discovered unlawful is later obtained independently by lawful means, it may also be considered admissible. That is, in Murray versus United States, 1988 reinforced this principle, where evidence found during an illegal search could be admitted if rediscovered without the influence of the initial breach. Some relevant US laws we will look into it is about the Fourth Amendment. Establishes the foundational protection against unreasonable searches and seizures. Federal Rules of Evidence, Rules 402 and Rules 403 provide the guidelines on admissibility, emphasizing fairness and excluding evidence deemed unfairly prejudicial or unlawfully obtained. Now we are going to look into Canadian case. In Canada, in according to the terms of general rules of admissibility, in Canada, the answer whether illegally obtained evidence is admissible is more nuanced. It depends on it. It it kind of depends. The Canadian Charter of Rights and Freedom, particularly Section 2 for 24 under the Section 2, requires courts to ask whether admitting evidence obtained through a charter breach would bring the administration of justice into disrepute. This approach reflects a balance between upholding individual rights and ensuring justice is served, especially in serious cases. Grant test. The key factors for admissibility. In RV Grant 2009, the Supreme Court of Canada established the Grant test, a contextual framework that outlines three key factors to assess the admissibility of evidence following a charter breach. Seriousness of the charter breach. The court considers the gravity of charter breach, giving more weight to deliberate reckless violation of rights. If the breach is minor or accidental, it may be more inclined to admit the evidence. Impact on the accused chartered protected interest. This factor looks at how significantly the breach affects the individual's protected rights, such as privacy and security. A severe intrusion on these rights would weigh against admissibility. Societal interest in a fair trial. The court also evaluates society's interest in ensuring that justice is served, especially for serious charges. In some cases, this consideration might tip the balance in favor of admitting evidence even when a breach has occurred. To maintain the integrity of the trial process, we are going to look into some relevant Canadian laws. Canadian Charter of Rights and Freedom, Section 8, protects against unreasonable search and seizure. Canadian Charter of Rights and Freedom, Section 24 bar 2, provides the framework for excluding evidence obtained through a charter violation if its admission would harm the justice system's reputation. To put into a summary, we can say the admissibility of illegally obtained evidence differs between the US and Canada based on each country's distinct legal principles. While the US exclusionary rule broadly prohibits such evidence with specific exception, Canada's grant test allows for a more case by case evaluation weighing individual rights against societal interests. These frameworks underscore each nation's approach to balancing personal freedoms with the need for effective law enforcement and justice. Now we are looking into the second question, which is about reasonable exception of privacy. Uh, Reasonable exception of privacy in computer systems in terms of and data, we are going to look into Canadian laws perspective. The concept of reasonable exception of privacy under Canadian laws plays a critical role in balancing individual privacy rights with societal interests, especially in digital age. Section 8 of the Canadian Charter of Rights and Freedom protects individual from unreasonable search and seizure, and this protection extends to data stored on electronic devices, whether personal or work issued. The list for reasonable exceptions of privacy has evolved to consider workplace and home settings, as well as new digital landscapes. 1. Defining the reasonable exception of privacy test. In Canadian law, the reasonable exception of privacy test assesses whether an individual can reasonably expect privacy in particular context. This test is vital for upholding privacy rights in digital context, examines factors like ownership, the location of data, and the presence of employer policies. The Supreme Court of Canada has applied this test in several cases to help define when individuals can expect their digital data to remain private. One of the key cases we are going to look, which is a case of Cole, R.V. Cole in 2012, SCC 53. I'm sorry if I'm pronouncing the RV as something like that. In that case, the Supreme Court considered the privacy rights of a high school teacher who was charged after explicit images were found on his work issued laptop. The main question was whether the teacher had a reasonable exception of privacy in personal files stored on a laptop owned by the school. Court's conclusion. The Supreme Court held that individuals do not automatically give up their privacy rights by using workplace technology. The court recognized that employees might retain a reasonable expectation of privacy over personal information on work issued devices, even if owned by their employer. We're going to look factors influencing privacy on workplace device. In the same case, the decision highlighted several key factors that establish an expectation of privacy in workplace issued devices. Personal use policy. The school in that particular case allowed incidental personal use of work devices. This policy strengthened the teacher's expectation of privacy as it implied some level of personal control over data stored on the device. Existence of personal files. The court emphasized that the presence of personal files on the laptop unrelated to work further established the teacher's expectation of privacy. Personal information intermixed with work data can imply an intent to keep certain data private. Nature of data stored. The court noted that privacy expectation increases with the sensitivity of data. For example, intimate or personal communications of or images likely carry a stronger expectation of privacy, even if stored on a work device. Though this decision, the Supreme Court set a significant precedent showing that workplace issued device can carry a reasonable expectation of privacy for personal information depending on the context and workplace policy. privacy in workplace versus home settings. In the context of workplace, we can see in a professional setting, employees may still expect privacy, but the expectation depends heavily on factors like personal use policies and employer monitoring policies. For example, if an employer has clear policies on monitoring workplace devices, an employee's privacy expectation may be reduced, though not necessarily eliminated. In terms of home, in a private setting, such as home, privacy expectations are generally much stronger. In the case of Morelli 2010 SEC 8, the court reaffirmed that data stored on personal devices in a private space such as home carries a high expectation of privacy due to intimate nature of personal data on computers or mobile devices. We are going to look into the final legal framework key Canadian legal references. Two critical legal references guide the reasonable expectation of privacy in Canada. Section 8 of the Canadian Charter of Rights and Freedom. The Section 8 forms the founding for protecting against the unreasonable search and seizure. It has been crucial in cases involving electronic devices where personal data could be accessed without consent. Criminal Code of Canada, Section 487 and 489. These sections outline the lawful procedures for search and seizure, ensuring specific standards and limits are followed when the authorities access data on electronic devices. To put it on a shorter note, we can say Canadian law recognizes that the reasonable exception of privacy extends to digital data even on the workplace issued device, as it's demonstrated in the case of Cole. While an employee's privacy expectation at work can depend on context and employer policies at home, privacy expectations are generally stronger. This nuanced approach ensures that the privacy rights keep with technological advances, preserving individual protections under Section 8 of the Charter. So now we are on question number 3. Does a concept reasonable expectation of privacy with respect to searches conducted by the police exist in the EU? Does it exist in the USA? Discuss and provide at least one legal references for each EU and USA. Long story short, yes, the concept of a reasonable expectation of privacy with respect to police searches exists in both European Union and United States, though it's interpreted differently in each jurisdiction. Here's an overview. We are going to look into this furthermore in detail in this upcoming slide questions. In terms of EU, the concept of privacy is protected under the Charter of Fundamental Rights of the European Union and the European Convention on Human Rights, ECHR. Specifically, Article 8 of ECHR provides the right to respect for private and family life, home and correspondence. This right has been interpreted by the European Court of Human Rights, ECTHR, to extend to a reasonable expectation of privacy, which protects individuals from arbitrary police searches and surveillance. Police and state authorities must respect these rights unless this is a legitimate reason, such as public safety or crime prevention, and the interference is proportionate. A key legal reference for this is case of Class and others versus Germany in 1978. The ECHR recognized that individuals have reasonable expectation of privacy in their private communication and activities. In this case, the court ruled that any interference by the state in a private person's private life, especially through surveillance or searches, must have a legal basis, serve a legitimate purpose, and be proportionate to the aim pursued. Thus, while EU does not explicitly use the term reasonable expectation of privacy, the concept is embedded within broader privacy protection afforded by the ECHR and applied through the case law. Now we are going to look into the case of US. In the US, the concept of reasonable expectation of privacy is foundational to privacy rights and has been established primarily through interpretations of the Fourth Amendment of the US Constitution, which protects individuals from unreasonable searches and seizures by the government. Fourth Amendment, the US Supreme Court has interpreted the Fourth Amendment to protect individuals' reasonable expectations of privacy, like meaning that if a person has a reasonable expectation of privacy in a particular place or a thing, police searches and seizures in that context generally require a warrant or a recognized expectation. For this, a key legal reference is Katz versus United States, 1967. This landmark Supreme Court case established the reasonable expectation of privacy holding that the Fourth Amendment protects people, not just places. In CATS, the court ruled that the government's placement of a listening device on a public phone booth violated CATS' reasonable expectation of privacy, setting a precedent that applies to a wide range of searches by the police. The reasonable expectation test from CATS continues to shape uh, privacy jurisprudence in the US, particularly concerning searches of electronic devices and surveillance. Both EU and US recognize a reasonable expectation of privacy, but they approach it differently. In the EU, privacy is framed broadly through fundamental rights with ECHR setting standards on what constitutes unjustified jurisdiction, unjustified intrusion. In contrast, in the US, the Fourth Amendment and the Supreme Court, precedents like Katz in the United States define the boundaries of privacy in terms of a reasonable expectations of privacy. Test that the police must respect except under specific, well-defined circumstances. Question 4. In Canada, when does the government, that is the Crown, need a search warrant to search and seize a suspect's computer? Name at least two legal cases from Canada which are examples of permitted warrantless searches. Name at least two legal cases from Canada when the court disallowed a warrantless search. In Canada, privacy rights around digital devices, particularly computers, are strongly protected under Section 8 of Canadian Charter of Rights and Freedoms, as we discussed above, like which guards against unreasonable search and seizure. As such, the Crown, aka the federal government, typically needs a judicially authorized search warrant to search or seize the suspect's computer. However, exceptions do exist, such as when immediate safety concerns arise or when evidence could be destroyed. First, general requirement for search warrants. To search a computer, the government generally needs warrant because computers hold vast amount of sensitive and personal information. This broad data scope significantly raises privacy interests, which the Supreme Court of Canada has consistently recognized as warranting protection. Judicial authorization for these searches is typically essential to avoid violating an individual's charter rights. Exceptions to the warrant requirement. While the general rule requires a warrant, Canadian courts have established exceptions under specific conditions. Exigent circumstances. When there is an imminent risk to safety or the potential destruction of evidence, law enforcement may conduct a search without a warrant. These circumstances require emergency where waiting for a warrant could compromise critical evidence or endanger life. Consent. If the accused voluntarily consents to a search, the need for a warrant is removed. However, this consent must be given freely and with full awareness of the rights being waived. Cases. We are going to look into some of the cases permitting warrantless searches of digital devices. Two key cases highlighted when the federal government or Crown may conduct warrantless searches of digital devices, either due to exigent circumstance or as part of unlawful arrest. R.B. Godoy, 1999 SCC 709, case number 709. Although this case did not specifically involve computers, it established a guiding principle for warrantless searches under exigent circumstances. In the Godoy case, the Supreme Court allowed a warrantless entry and search when there was an immediate threat to safety. The decision implies that if a similar threat existed involving digital evidence, a warrantless search could be justified to prevent evidence destruction or protect public safety. The case of Fearon 2014, case number 70, SEC 77. In the case of Fearon, the Supreme Court ruled the police could perform a limited search of a suspect cell phone without a warrant if it was directly related to the purpose of an arrest. For instance, if the arrest aim was to prevent evidence destruction or ensure immediate safety, police could search the device in a scope limited manner. However, this search must be strictly tailored to avoid unnecessary protection. Now we are going to look cases disallowing warrantless searches of digital devices. The Supreme Court has underscored that due to extensive privacy concerns, digital devices raises concern. Warrantless searches are generally impermissible unless very specific conditions are met. The case of Wu, 2013 SEC 60. This case emphasized that the unique privacy expectations surrounding computers in current computers. In in the case of the Wu, the court ruled that a general search warrant for a residence did not automatically permit police to search computers found inside. The rule clarified that computers require specific authorization within the warrant due to the vast amount of personal information they contain, which differs significantly from physical items in a home. Therefore, a general premises search warrant does not cover digital devices without express judicial approval. The case of Cole 2012 SEC 53. In the case of Cole, the court examined the privacy of digital devices in a workplace setting. Here, a teacher was found with personal information on a work issued laptop, and the police conducted a warrantless search of the device. The court ruled this search unlawful, stating that even though the laptop belonged to the employer, the personal file it contained created a reasonable expectations of the privacy. This decision reinforced that police need a warrant to access personal data on digital devices even when issued by an employer, bearing any exigent circumstances. To conclude, you can say that under Canadian law, the government typically needs a search warrant to search a computer due to high privacy interest involved. While cases like Godoy or the fear on show that exigent circumstances or the immediate purpose of an arrest can permit a limited warrantless search, these are exceptions rather than the rule. The landmark cases of Wu and Cole confirm that digital devices hold a high level of personal information requiring specific judicial authorization for searches, even in cases where the devices are work issued. Damn, I need water. Question number 5. Explain the concept of exigent circumstances under Canadian law. Which type of exigent circumstances might arise in a respect to computer data and digital forensics? Discuss and provide one legal reference from Canada. Exigent circumstances in Canadian law. In Canadian law, exigent circumstances refers to situations where immediate action is essential, allowing law enforcement to search or seizure without a warrant. This exception is rooted in Section 8 of the Canadian Charter of Rights and Freedom, which protects individuals against unreasonable searches and seizures. Exigent circumstances are uh, are invoked when delaying action to obtain a warrant would compromise public safety or risk the destruction of evidence. Today we are going to look furthermore into these concepts, and the first one we are going to look at the concept of exigent circumstances. Exigent circumstances are an exception to the unusual warrant to sorry exigent circumstances are an exception to the usual warrant requirement, allowing law enforcement to act swiftly when waiting for a judicial authorization could lead to severe consequences. There are two primary triggers for invoking exigency: immediate threat to safety. If waiting for a warrant would create a real risk to public or officer safety, the police may act without one. Risk of evidence destruction. In case where evidence might be lost, destroyed, or tampered with before a warrant can be obtained, police may search or seize to preserve crucial evidence. These circumstances are intended to balance public interest in safety and justice with the individual right to privacy. Exigent circumstances under digital forensics. Digital forensics present unique challenges when it comes to exigent circumstances, particularly due to volatile nature of electronic data. Here are like some of the examples which we are going to look, like three examples we're going to look into to understand warrantless access of digital devices or that may justify it. Risk of evidence destruction. Digital evidence can be easily erased, often remotely or by automated functions. For example, a law enforcement may act without a warrant if they believe that the data on a suspect's computer could be deleted, overwritten, or altered before a warrant is issued. Ongoing crime or imminent arrest. If a digital device holds crucial information relevant to an active crime, and warrantless search may be necessary. For instance, data on phone could reveal the location of accomplices or evidence of further criminal plans. This justification hinges on potential to prevent immediate harm or further criminal activity. Officer or public safety. If there are credible threat to safety, such as messages or evidence of a planned violence on a device, law enforcement might be justified in conducting an immediate search. Protecting lives can take precedence over the typical warrant requirements in urgent situations. Case law example of Ferron 2014, case number SCC case, Supreme Court of Canada, case 77. The Supreme Court of Canada has addressed exigent circumstances in digital context, notably in the case of Ferron. In Ferron, the court ruled that police could conduct a limited warrantless search of a mobile device during a lawful arrest if search met certain criteria. This case involved a suspect arrested in connection with a robbery, and police searched his cell phone without a warrant. This decision established a framework for warrantless searches under exigent circumstances in digital forensics relevant to arrest. The search must be directly related to the arrest purpose, such as seeking evidence pertinent to the crime. Um, Narrow scope. The search must be confined to the relevant areas of the device, avoiding extensive browsing of unrelated data. Protection of evidence. If there is a credible threat that evidence on device may be destroyed or tampered with, immediate access is justifiable. Officer safety. If the device content suggest uh, content suggests an imminent threat, a warrantless search may be warranted. In the case of Ferron, emphasizes that exigency does not permit unrestricted access to digital devices such as devices. Each warrantless search must be limited to scope and reasonable under certain circumstances, respecting Section 8's privacy in protection. Balancing the privacy and immediate needs. The Supreme Court, in the case of Ferron, laid out the principles that warrantless searches should always be measured against privacy considerations. Exigent circumstances must justify the need for immediate action, and any search conducted should be specific, targeted, and minimally intrusive to protect individuals' privacy rights. Other cases, such as R.B. Godoy, reinforce that warrantless actions are only justifiable under genuinely pressing situations. This highlights the Canadian law prioritizes privacy but recognizes the need for flexibility in urgent safety-related situations. To put it in a picture, we can say that Canadian law exigent circumstances create a pathway for immediate action where necessary is necessary, especially in scenarios involving digital evidences where data can be volatile. However, each situation requires a careful balance of a public safety needs and the individual's right to privacy. Under the charter case like RV Fioron, demonstrate that the scope of any warrantless search must be justified, limited, and closely aligned with the urgency of the situation, reaffirming Canada's commitment to both justice and individual rights in the digital era. Question number 6. What should a computer forensic investigator do if a computer that is being searched is found to contain privileged information? Discuss and provide one legal reference from Canada. Handling privileged information in computer forensics. In Canada, computer forensic investigators have strict responsibilities when they encounter privileged information like solicitor client communications during a digital search. This information is legally protected under Canadian law, particularly by the Section 8 of the Charter, which guards against unreasonable search and seizure. Improper handling could breach privacy rights, so investigators must follow specific steps to ensure confidentiality. Steps for investigators. One is going to be cease review immediately. Upon recognizing potentially privileged data, the investigators should stop examining the files to avoid inadvertently accessing sensitive material. Segregate the privileged information. The investigators should separate privileged information from other data, often by using a clean team or a designated individual who handles privileged files separately from the main investigative team. Notify authorities or legal counsel. It's essential to inform supervising authorities or a legal counsel, such as Crown Prosecutor, about the privileged information. This ensures that the handling aligns with legal protocols and protects the rights of the individuals involved. Seek judicial guidance if necessary. If there is any unnecessary uncertainty, investigators may request judicial directions. court can provide instructions to ensure that privilege protections are respected throughout the investigation. Uh, Key reference can be of Laville, Rackle, and Haynes versus Canada. In Laville, Rackle, and Haynes versus Canada, the Supreme Court of Canada ruled that searches involving privileged information require rigorous safeguards. This case emphasizes the need for forensic investigators to halt, review, segregate, and handle the privileged data with legal oversight to maintain confidentiality and uphold the privacy rights. In Canadian law, the computer forensic investigators must take immediate and careful steps when encountering privileged information. Following procedures such as stopping review, isolating the data, notifying authorities, and possibly seeking court directions uphold both legal standards and the privacy rights of the individuals involved. Question number 7. What is MLAT? Why it's important? How, why, and when it might be used? Give one legal reference and where MLAT was used in Canada. MLATs and legal evidences. Mutual legal assistance treaties, MLATs, are agreements that provide a structured process for obtaining evidence across borders in criminal cases. The process is particularly valuable for accessing legal evidence, that is, information or documents that are legally gathered and admissible in court to prove facts in a criminal case. In cross-border investigations, the investigation evidence could include electronic data, financial records, or physical documents. Key elements of a legal evidence through MLAT. Evidentiary integrity. Legal evidences obtained through MLATs must be collected in a manner that respects both the requesting country's needs and the requested country's legal protections. For instance, Canada's legal systems require compliance with privacy rights under Section 8 of the Canadian Charter of Rights and Freedom, which protects against unreasonable search and seizures. MLATs help MLATs help uphold these standards internationally, ensuring that evidence gathered abroad is legally admissible in Canadian courts. Chain of custody. When evidence is shared between countries, MLATs ensure a clear chain of custody. This means that there is a documented, reliable record of every person who handled this evidence, from the point of collection to its transfer to the requesting country. This is critical in maintaining the integrity of the evidence and avoiding allegations of tampering and or contamination. Adherence to domestic legal standards. The requested country will only release evidence that implies within its own laws. For example, Canada would only provide evidence to a foreign country under an MLATs if doing so complies with Canadian law, including privacy protection and procedural strength. MLATs usage example, which is going to be United States since Sri Skandaraja in 2012. In the United States Sri Skandaraja 2012 case, the United States requested assistance from Canada to obtain evidence for terrorism investigation. Using the US Canada MLAT, Canadian authorities collected digital evidences that included electronic communication and records which were crucial for the prosecution in the US. The use of MLAT ensured that Canada's legal standards for evidence collection were respected, allowing the evidence to be lawfully admissible in both Canada and US court. This case highlights the importance of MLATs in enabling lawful cross-border evidence sharing while upholding privacy or procedural safeguards. In the essence, MLATs are vital for securing legal evidence that meets both international cooperation requirements and domestic legal standards. They support cross-border investigation by establishing a reliable and a lawful framework for gathering evidence that respects the sovereignty and principal privacy laws of each country involved. The Sri Skandaraja case exemplifies how MLATs help streamline evidences sharing in a way that both respects individual rights and aids in the prosecution of serious crimes. Question number 8. Name three privacy principles used elsewhere in the world that are not part of Canada's 10 privacy principles. Explain the utility of each as well as any associated problems. Provide two legal references from anywhere in the world related to your three principles or any over them. Three principles not in Canada's 10 privacy principles under PEDA. Here are key principles from global privacy frameworks that are not directly included in Canada's Personal Information Protection and Electronic Documents Act (PIPEDA). One, data minimization. Uh, GDPR, that is part of GDPR in Europe. Data minimization is a core principle under the EU's General Data Protection Regulation (GDPR). In Article 5 slash 5 or 1 part of C, Section C, it mandates that the organization only collects the minimum personal data necessary for their purposes. This principle is beneficial for reducing privacy risks by limiting data exposure and encouraging organizations to carefully assess data needs before collection. But the problem here would be like a challenge with minimum data minimization is that organizations may struggle to anticipate future data needs. This may restrict flexibility in data processing or require costly recollection efforts in further if further data becomes necessary for legitimate uses. Then next one is RTBF, aka Right to be Forgotten, aka Right to be Forgotten, part of GDPR Europe. The right to be forgotten empowers individuals to request deletion of personal data when it's no longer necessary or when consent has been withdrawn. This principle enhances individual control over personal information, supporting privacy by allowing people to manage their digital presence. RTBF is a complex implement due to technical and legal challenges. Data may be replicated across platforms and exception to RTBF exist, such as those concerning freedom of expression. Smaller organizations may face additional burdens in ensuring compliance across diverse data repositories. Some legal references for this would be regarding Google Spain, which is agency of Spain's protection of data, which is Española de Protección de Datos. This landmark case from the Europe Court of Justice established RTBF in EU law, holding that search engines must, under certain circumstances, comply with requests to remove personal information. Now we are going to see uh, purpose limitation. OECD Global. Purpose limitation emphasized in the OECD Guidelines of the Protection of Privacy and Transborder Flows of Personal Data 2013 revision restricts the use of personal data to specific legitimate purpose by confining data use to original purposes. This principle minimizes the risk of data misuse and builds trust that data won't be used in ways individuals did not respect. Purpose limitation can make data processing rigid. Secondary data uses, such as research or analysis, may be hindered if data's original purpose doesn't align with new applications. Organizations might also face difficulties in accessing what constitutes compatible purposes, impacting innovation and adaptability. In short, we can say the data minimization, the three principles data minimization, the right to be forgotten, and purpose of limitation play a crucial role in safeguarding privacy by limiting data use, giving individual control over their information, and protecting intended purposes. However, each poses unique challenges and often require complex legal and operational adjustment for effective implementation. All right. Question number 9 is as simple as it is privacy versus security. Um, so, in terms of privacy versus security, let's do it in a different way. Like, since this is a most commonly discussed topic around, and I want to make sure that I would like to go it in a much more layman process so that it is pretty understandable, or at least from my side. Let's think of a privacy and security as two bouncers at the entrance to the VIP area of the personal data club. Each has a different role, but both are key to keeping your data club safe and sound. Privacy. Privacy can be like your social media bouncer. Like privacy is like the bouncer who makes sure no one unauthorized sneaks into your personal space. This bouncer is all about who gets in, why they are there, and if you're totally cool with them being around. Privacy is about being around. Privacy is about control, choice, and protecting the right to say, oh, not everyone can know about this about me. For example, privacy regulations like GDPR or PIPDA PEDA, are the club rules stating that people need your permission to enter your data space, and that they should use the info only for the purpose they promised. Privacy cares if someone is snooping where they shouldn't be, even if they aren't technically allowed inside. Security. This is like the your ex Navy SEAL bouncer. Security, on the other hand, is like trained to keep out hackers, cyber thieves, and anyone trying to break in without a pass. Security's job is about how to protect the data, not who has access to it. The bouncer relies on muscle of encryption, firewall, layers of digital defenses to stop any shady characters getting from their hands on your data. Security makes sure that once someone has been granted access with privacy's approval, of course, no one else can sneak past with a brute force their way in. So the question is, which one is harder to maintain? If you ask me, I feel like privacy is often harder to maintain over time due to complex requirements for compliance and the evolving expectations around around the data usage. Uh, Privacy mostly evolving legal requirements, like privacy standards are very widely across jurisdictions and are frequently updated, making compliance more complicated. Organizations must consistently adapt to laws like GDPR, CCPA, which requires changes in data handling practices, privacy policies, and individual consent mechanisms. User data and control. Privacy requires continuous oversight to ensure that data collection aligns with what individuals have consented to. This is challenging as organizations must constantly monitor data usage, often across multiple platforms and departments, to prevent unauthorized sharing or misuse. Data profiliation and analytics. With the rapid growth of data and advanced analytics, maintaining privacy is complex. Companies are pressured to use data for insights, but doing so while honoring privacy principles like data minimization or purpose limitation is increasingly difficult. Security, while still challenging, is more straightforward in that it involves protecting data against defined threats. Tools like encryption and firewalls can be applied broadly, whereas privacy requires a more nuanced, context-specific approach, continually adapting to legal and ethical expectations. Question 10 is, what is PIA? When should be performed? What types of findings are typically uncovered as a result of performing PIA? Are PIAs legally required to be performed in Canada? If so, under what circumstances? Let's start with a simple question. What exactly is PIA? Privacy Impact Assessment. A PIA is essentially a privacy detective work. It's a systematic review process designed to identify and protect personal information before potential risks become real problem. Think of it as a privacy health check for your organization's data practices. When should you perform a PIA? The answer is simple. Anytime you're dealing with personal information or in a new or changing context. This could be launching a new technology, implementing a digital services, or making significant changes to system existing systems. Uh, so let me discuss with some real world trigger points. You need a PIA when you are implementing new technologies, launching digital services, making substantial system changes, collecting personal data in new ways, transferring information across borders. Now here's where it gets interesting. What do we typically uncover during a PIA? We find some eye-catching red flags: unauthorized data access vulnerabilities, weak protection mechanism, instances of excessive personal information collection, unclear consent process, potential data misuse scenarios, compliance gaps that could leave your organization exposed. In Canada, PIAs aren't just a good idea; they're often a legal requirement for federal institutions. It's mandatory under the Privacy Act. The Treasury Board Secretariat provides clear instruction, and the Privacy Commissioner strongly recommends the comprehensive assessments. To break down PIA, it's why it's absolutely necessary in Canada is that government system in places like such as government system developments, sensitive data collection projects, cross-border information transfers, new program implementation, significant technological changes. Um, the process of PIA isn't that complicated though. Initial risk assessment, detailed information flow analysis, identifying potential risks, developing mitigation strategies, comprehensive documentation, and continuous monitoring. So, why does it matter though? Because privacy is not a luxury, it's a fundamental right we must protect. Although PIA demonstrates organizational accountability, prevents potential data breaches, and build customer confidence. To protect yourself in a better place in a company like Canada, so how to do this, how to access this? To do this, we have to develop a robust PIA framework. We have to train them according to this, create a solid documentation process, and implement regular review mechanisms. In today's world, protecting information isn't just a legal requirement, but it's moral imperative. We are doing question 11 right now, and in question 11, we are taking out PHPI decision 114 from the Ontario Information and Privacy Commissioner's Office. Um, PIPHP Decision 114 from the Ontario Information and Privacy Commission Office. Um, this report explores privacy and information handling in the context of healthcare data, focusing on an incident where a hospital employee accessed patients' personal health information, that is PHI, without authorization. This analysis will examine the summary connected to a broader privacy issues like data security and evidence handling and provide a critique with legal context. The summary is in PHIPA Decision 114, an Ontario hospital reported that one of its employees had reportedly accessed patient records without permission. The investigation revealed that this access occurred over a period of time, and in many cases, the employee had no critical reason for viewing the information. Decision by the Information and Privacy Commissioner, that is IPC, examined that the hospital's obligation under the Personal Health Information Protection Act (PHIPA) and determined whether it adequately protected sensitive patient data. The findings indicated that the hospital's existing auditing processes were insufficient to detect and prevent such breaches promptly. The report recommended that the hospital implement more stringent access controls and monitoring systems, ensuring that the authorized personnel could view sensitive information. It also urged that the hospital to reinforce its training protocols, educating staff on the importance of data privacy and the legal consequences of unauthorized access. In terms of these topics, in context, we can say that in terms of privacy, the report touches on central theme in privacy studies: the need to balance access information with privacy protection. In healthcare, professionals require access to PHI to provide effective treatment. Yet there is an imperative restrict access to only those involved in patient's care. PHIPA aims to ensure such protections by settling out rules for handling personal health information and mandating that organizations enforce these standards. The case underlines the tension between the necessary access for service provision and the patient's right to privacy, and especially concerning the sensitive health data, search and surveillance. Another relevant aspect is the hospital's approach to monitoring the data access. Routine audits and regular access logs are essential tools in data security, helping organizations track who views sensitive data and under what circumstances. However, as the decision reveals, auditing alone is insufficient if it's not frequent enough to catch breaches in a timely manner. The report's recommendation for a more proactive auditing aligns with discussions about reasonable surveillance measures with the organization to safeguard against internal privacy threats. Evidence. In privacy breaches, the evidence obtained through audit or logs becomes essential for disciplinary actions, legal proceedings, or privacy reports. In this case, audit logs provided critical evidence of unauthorized access patterns. Effective data handling and logging practices ensure that this information remains admissible and accurate. Moreover, failure to monitor or act on such evidences can be a significantly liability for organizations, emphasizing the need for robust internal security practices. Computer security. This report underscores the importance of comprehensive computer security frameworks, especially in sectors handling sensitive information. Effective computer security involves not only data encryption and access restrictions, but also internal oversight, staff training, and proactive breach detection mechanisms. This incident reflects a common gap in organizations security measures uh, where security measures focus more on external threats than internal actors with unauthorized access who misuse it. Strengthening protocols to address both external and internal vulnerabilities is crucial for data integrity, critique, and personal assessment. The IPC's approach in PHIPA decision is well reasoned, and I agree with the recommendation for improving auditing, access controls, and staff education. The hospital's initial response to the breach, while acknowledging the unauthorized access, lacked the mechanism for proactive breach detection. Had the hospital implemented real time monitoring or frequent audits, the unauthorized access might have been detected sooner, limiting the scope of privacy breach. However, while the recommendations are sensible, there is room for specific guidelines on implementation. A requirement for a real time data access alerts or artificial intelligence driven monitoring could provide an extra layer of security. Additionally, the report could have recommended consequences for non compliance to drive accountability with the organizations. Some of the examples for these ones are RV Cole 2012 case. The Supreme Court Canada sets a precedent handling unauthorized data access within organizations, underscoring employees' limited expectations on privacy devices. This case suggests that the idea organizations must provide sensitive data. They also have grounds to monitor employees to prevent misuse. Similar to the PHPA cases, RV Cole highlighted the importance of establishing clear boundaries for data access and accountability. Privacy Act 1988, Australia. In Australia, the Privacy Act mandates protection for personal information, requiring organizations to take reasonable steps to protect data from unauthorized access. Cases handled by the Australian Privacy Commissioner, such as the one linked above, emphasize the comparable principles of data minimization, restricted access, and the periodic auditing to prevent breaches. Australia's Privacy Act and PHIPA both demonstrate an universal trend towards stricter data governance and accountability. Ontario's health privacy principles. Under Ontario's PHIPA, organizations must limit to PHI based on the need to know principle, ensuring that only relevant personal access sensitive information. This framework directly aligns with the IPC's recommendation for restricting access within the hospital. Ontario's health privacy principle reinforced the need for continuous employment and training and data monitoring to protect patient confidentiality. PHPA Decision 114 highlights the critical role for internal privacy and security protocols in health organizations. This report recommendation are in line with the best practices, stressing the importance of proactive monitoring, frequent audits, and staff training to prevent unauthorized data access. While IPC's conclusions are sound, the report could benefit from more specific implementation and guidelines and stronger compliance incentives. Cases like RV Cole and the Privacy Act in Australia illustrate the global emphasis on protecting personal data within organizations, settling legal standards that prioritize both organizational accountability and individual privacy rights. With this, I would like to conclude my assignment tree. Thank you.